Federal Court's docket on the plaintiff mother's motion to suspend defendant father's parenting time. A motion was filed requesting ex parte relief. The court denied that ex parte relief on December 21st. Mr. Musser was given a hearing date for today's date and time. This hearing is being conducted via Zoom in addition to Mr. Musson being present. Christina Bays is present, but the defendant father, Jeffrey Toval, is not present. Mr. Musson.
Good morning, Your Honor. We sent the original motion out. When I talked to the court, we got the hearing date for today. I sent the notice of hearing, and I sent I have a notice of hearing. I have a proof of service. The notice of hearing is not filed with the court. That went out on the 28th for the 4th. So that's 28, 29, 30, 31, 1, 2, 3, 4. So exactly 7 days, but unfortunately, I did get in contact with defendant's counsel. He's emailed me back that he has not been retained for the matter. So I had previously sent previously sent an updated motion before the friend of the court by email to Mr. Tuval. That bounced back, so the email wasn't good. So I was only left with the mailing. And by court rule, the mailing is, I think, 9 days if by mail?
Correct.
So we don't have the 9 days.
Okay. All right. We'll note for the record then. Mom is still exercising her parenting time that she was recently awarded, correct?
Well, we have a referee. It's whatever the award was in, I believe it was August.
August, correct. The parties mediated with Mr. Pratt, and the court entered a consent order. Mom, during the school year, mom had parenting time from Fridays, unsupervised, Fridays at 4 o'clock to Sunday at 7 o'clock, the first, second, fourth weekend, and the fifth, if it exists, of each month. So Miss Bays has been having contact with 5-year-old daughter. Is that correct?
Yes.
Yes.
Okay. All right.
And I think that I guess it's going to depend on Mr. Tavella. I'm looking up when the hearing date was on the friend of the court. Because the friend of the court, I believe the friend of the court order suspends his parenting time. But he didn't appear for that hearing.
Well, if there's already a friend of the court referee hearing, why is there another hearing?
Based on the allegations. We need to suspend.
So the referee recommended suspension of dad's parenting time, but what, a review on January? Is that correct?
I believe so, yeah.
All right. So there's nothing in the court file, perhaps the 21 days has not yet expired?
And I don't believe so, no.
It's coming up January 9th at 10:30.
No, 21 days.
We're not in objection period because it hasn't happened yet.
Okay. I thought the referee recommended an order that suspended dad's parenting time, but set it for a review on January. That's what I get the court's confused as to what's going on. Again, until 20 days expires, the referee recommended order does not appear in the court files, not sent to the clerk's office. But you're suggesting, Mr. Musson, the referee recommended order suspend dad's parenting time, but also set up for review on January 9th, apparently?
I believe so. I got an email from the court. Well, from the referee, Stephanie. It was Stephanie LaPrade. So she had emailed us on January 2nd.
Yeah, I don't know what that's about. I thought Jennifer Homrick was the referee that handled this matter, so I'm confused. But in any event, the matter's off of today's docket, and we'll wait. If you want, you can get from Miss Nancy another hearing date.
Yes.
In case, according to the court records, there's some sort of hearing in January. I'm not sure. Who's that before?
This is a show cause hearing, January 9th at 10:30, and it just says referee.
Okay, there's a show cause hearing before the referee on January 9th at 10:30. I'm not sure who's a motion for a show cause that is.
I'm aware of it.
Okay, so is Miss Bays seeing the minor child right now? Is the dad denying parenting time?
No, it was dad's filed a motion for enforcement request, which led to the show cause because of the CPS investigation. Mom denied the parenting time.
She cannot do that. She cannot do that. Miss Bays, where's the child right now? Have you been withholding the child from dad?
No.
Okay, until you get a court order, a recommended order It's just that. It's a recommend order, but you cannot just on your unilaterally deny parenting time to dad. So right now, dad has parenting time during the week. Is that correct? And you have on weekends?
Yes.
Ms. Bays?
What?
Is your daughter with dad during the week?
Yes.
All right. Okay. All right. Just want to make sure you're clear that you can't just deny parenting time because CPS suggests you should do that. You need a court order, and there's no court order that suspends dad's parenting time right now. I don't know the status of the recommend order, but in any event, anything further, Mr. Wesson? I guess if that'll conclude the member, go off the record, and if you want to get a date from Nancy here in our motion hearing date, for the record, before the court, give you some dates. Parties having
Yes,
engaged in mediation with Ms. LaPrade for the front of the court this afternoon. This morning, I should say, President Attorney Kirsty Nemec representing the plaintiff, Barbara Castaldi. Ms. Castaldi is present. In addition, Attorney Jason Kazmarek is present representing the defendant, Albert Castaldi, and Mr. Castaldi is present. Court has been informed the parties have reached their own agreement. Is that correct, Ms. Nemec?
It is, Your Honor.
Wonderful. Of course, with this agreement this morning, the court will vacate the pretrial conference scheduled for tomorrow morning, February 5 at 8:30. All right. Who would like to place agreement on the record?
I can do that, Your Honor.
Please, Ms. Nemec.
So the parties agree that Mr. Castaldi, the defendant, will be entitled to spousal support in the amount of $1,100 for a period of 8 years, commencing on February 1st, 2024. That amount will be modifiable as to duration and amount, and will terminate upon Mr. Castaldi's death, or I'm sorry, Ms. Castaldi's death, Mr. Castaldi's death, or Mr. Castaldi's remarriage. The parties have multiple retirement accounts. Each will keep their own retirement account. So Mr. Castaldi has an IRA, Ms. Castaldi has a 401k, and they will each be entitled to keep their own. Ms. Castaldi, however, has a pension. Mr. Castaldi will be entitled to half of the marital portion. The parties agree to use Ms. Pastrana to draft the qualified domestic relations order, and each will be responsible for any costs or fees associated with that quadro. Each will keep their own vehicle and be responsible for all costs associated therewith, and will hold the other party harmless. Each party will keep their own debt and will hold the other party harmless. Each party has a separate bank account. They'll be entitled to the bank accounts in their own individual names. There is one third account that still has both parties' names on it. The parties will work together to either close that or remove Ms. Castaldi's name from it, and that will occur within 14 days of the date of judgment. The parties have a timeshare with Travel Advantage Network that's awarded to the plaintiff, Ms. Castaldi. Each party will provide the required documentation within 14 days of the judgment of divorce to effectuate this transfer. There are cell phones that were previously on Ms. Castaldi's account. She is going to be able to remove the 2 lines. Mr. Castaldi has already set up or established cell phones, his necessary cell phones in his own name. Each party will keep the property that's currently in their possession, and Ms. Castaldi is not looking to restore her former name. And that's the entirety of the agreement.
Thank you. Spousal support as to Barbara is Reverend Bard. Is that correct?
That is true. Yes, thank you.
All right. All right. Thank you, Ms. Nemec. Mr. Kazmarek, did Ms. Nemec accurately state your client's agreement?
Yes.
And you are the plaintiff in this action for divorce, correct?
Correct.
At the time that you filed your complaint for divorce, had you lived in the state of Michigan for at least 180 days?
I did.
And at that time, had you also lived in the county of Monroe for at least 10 days?
I did. Yes.
Are you and Mr. Castaldi were married July 15th, 1989?
Correct. Yes.
And you have no minor children, correct?
Correct.
And are you currently pregnant?
No.
Okay. And do you state to this court that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there's no likelihood that the marriage can be preserved?
Yes.
Okay. Did you hear the agreement that I placed on the record?
Yes,
Did you understand it?
I do.
Do you have any questions about it?
I do not.
Have you had time to think about it?
I have.
Have you had time to discuss it with me?
I have. Yes.
Is anybody forcing you to enter into it?
No one is. No.
You understand that by placing this agreement on the record today with Judge Braunlich, that makes the agreement binding.
I do. Yes.
And so you understand that you can't come back tomorrow or 5 years from now and ask the judge to make a change to the property distribution aspects of this judgment.
Yes, I understand that.
The only exception to that would be spousal support because it's modifiable.
Correct. Yes, I understand that.
But you understand that spousal support as to you is forever barred. So that means you can't come back and ask the judge to award you spousal support.
Correct.
And you know that you could have taken this case to trial and the outcome could have been different. It could have been better or worse or the same.
Yes, I understand that.
But rather than go to trial, you're asking the judge to adopt the agreement that I placed on the record and turn it into a judgment of divorce.
I am. Yes.
You understand that you were entitled to conduct further discoveries, such as sending subpoenas to get records relating to Al's separate accounts. But by putting this agreement on the record, you're ending your ability to look into those matters.
Yes, I understand that and agree to it.
Okay. Have you disclosed all of your assets?
Yes, I have.
Okay. And are you satisfied with my representation?
Yes, I am. Thank you.
I have nothing further, Your Honor.
Thank you, Ms. Nemec. Mr. Kaczmarek, first of all, do you have any questions for Ms. Castaldi?
I do not.
Okay, questions for Mr. Castaldi, please?
Please, yes. Al, please state your name.
Albert, middle Paul Castaldi.
And again, you've heard the agreement placed on the record today,
I agree.
and you've heard it though, correct?
Pardon?
You've heard the agreement on the record today.
Yes.
Okay, and so do you understand it?
Yes.
And we're involved in a fairly lengthy mediation this morning. Is that correct? Where these all
Yes.
terms were discussed.
Yes.
And you understand. Actually, the agreement on the record today is what you want to be your final agreement. Is that correct?
Correct.
Okay, and you understand you could go to trial, you could get more, could get less, but the terms stated today are your full and final agreement.
Yes, they are correct.
And are you satisfied with my representation?
Absolutely.
Do you have any questions about the agreement at all?
I do not.
I have nothing further, Judge. Thank you.
Thank you, Mr. Kaczmarek. Ms. Nemec, do you have any questions of Mr. Castaldi?
I might have missed this, but Mr. Castaldi, have you disclosed all of your assets?
Yes, I have.
I have nothing further.
Thank you. You'll prepare the judgment, Ms. Nemec?
I will.
Well, thank you. The court would like to thank and acknowledge Ms. LaPrade from the front of the court for her assistance, as well as, of course, attorneys Nemec and Kaczmarek for helping facilitate the amicable resolution. The court would applaud the two of you, Mr. and Ms. Castaldi, for reaching your own agreement. Without question, the best resolution of matters of this nature is one which you both participate and ultimately agree upon, as you have this morning. Far better off to have the court make these decisions. In any event, based upon the testimony that's been presented, as well as plain filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the opposite matrimony has been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day. Thank you again, Ms. Nemec and Mr. Kaczmarek.
Thank you, Your Honor.
Thank you, Your Honor.
Status of the welcome. Appeared, I believe, last week. Court was informed that he's on felony probation. The matter was adjourned to today's date to determine the status of the felony probation matter. Obviously, Mr. Baker has not been able to post the bond. Ms. Six, do you have any updated information on Mr. Butler?
Yes, Your Honor. So upon review of AS 400, he was arraigned by Judge White on that violation of probation. He does have a $75,000 cash surety bond on that with a hearing that is set for later today. So at this time, the friend of the court doesn't anticipate him posting that bond or going anywhere on that one. So we would like to just give him credit on his previous finding of contempt and ours for the time served and not eat up any more of our potential jail time. So he would be entitled to 12 days jail credit today, Your Honor.
Excuse me, Your Honor, may I say something?
Yes, Mr. Butler.
I know me and Mr. Silver's history is not good, but the past 2 years I've been illegitimate on paying for Miss DeSilva's child. How can I go about signing off my rights to where I just paid the back pay and let Mr. Silvis and her daughter finish their life without me being involved in it?
I can't act as your lawyer, Mr. Butler, but that's something you should talk to Mrs. Silvis about. Again, if in fact she may not want to raise her daughter without a father, so something you have to agree upon.
It's been planned for that. She's been telling me that for years, and I've been not wanting to do that. But there's a no contact order between me and Mr. Silvis, so I can't talk to her.
Okay, well, maybe have an attorney do that.
Okay.
Or a family third party or something. I don't know about the no contact. In any event, that's something you need. That's something you did with outside of this matter. This is simply we're enforcing child support.
Okay, I appreciate it. I apologize. Thank you.
Your friend court caseworker. Keep in contact with your friend court caseworker. Make some effort to pay some child support. In the meantime, even if your criminal rights are terminated, it doesn't eliminate past support.
Yeah, exactly. I understand that. I don't even know who my friend of the court attorney is.
Your friend of the court caseworker, you just come to the window, come down to the front of the court, and they always keep them updated as your address. They have a 4-page list of employers that are screening for employees. And Mr. Butler, they can help you find a job, and you have a caseworker that's assigned to your case and you can talk to about these matters.
Yes, sir.
You just got to come to the front of the court window. They can tell you who that person is.
Yes, sir.
Ms. Six, is Mr. Rollins entitled to 12 days or 9 days credit? He was arraigned on December 27th, correct?
He was arrested on the 24th, Your Honor.
Okay, but this court didn't see him until the 27th?
Because we were closed for the holidays, Your Honor.
Gotcha. All right. Okay. All right, Mr. Understand now. So, Mr. Butler, the court's going to give you credit for the 12 days you have served. And then there'll be a personal bond in this matter. You just got to deal with the criminal charge. So you had 41 days hand of your head. We're going to subtract 12 days from that, the credit you're given. You got to remain 29 days hand of your head. You hold the key to that 29 days. You can avoid any additional time if you keep contact with your friend court caseworker.
Yes, sir. Thank you.
And just appear when required. Make some effort.
Yes, sir.
So again, the court will already serve 41 days in jail. A credit for 12, about 29 is suspended. And on this matter, you're released on a personal bond. Keep in mind, you got arrears in excess of $22,000. I think you don't want to sit in this matter because the Attorney General could be coming along and charge you with felony non-support if you don't really take care of these arrearages, making some effort.
Yes, sir. I understand.
All right. Any other questions, sir?
No, sir. Thank you. God bless and Happy New Year.
Yep. You as well.
Can we set a review date in this matter for February 27th at 8 a.m. though? Just so I can keep tabs on what's happening in his violation and give him the opportunity to come over and he can ask to speak with me and I can help him direct him to his caseworker.
All right, Mr. Butler, the court's going to set this matter for review February 27th, 2024, 9 a.m. And after this order will be mailed or will be sent over to the jail. You get a copy of this. And you got to just appear on February 27th, 9 a.m. if you're in jail. Ms. Hicks will locate you and schedule the meeting via Zoom. If you're out, you need to be in front of the court. So when you're out, come over to the front of the court. You come in advance of the February 27th date and just get a job list and talk to your caseworker. But you need to appear on February 27th for Ms. Hicks to review this matter. Okay?
Yes, sir. Thank you.
Okay, you can step out, sir. Are you Christopher Papin Sr.?
Yes, Your Honor.
All right, I need that. Mr. Papin is before the court for a review, having been arrested on a front court bench warrant last week. The matter was adjourned to today's date to determine the status of a felony probation action that was pending. Ms. Hicks, can you update the court?
When I reviewed this case this morning, Your Honor, he was arraigned on his, he had 2 violation of probations, each received a $10,000 cash surety. However, the AS 400 did set his next hearing for this morning, and so it has not been updated since that time. So I'm not sure, Mr. Papen might be able to answer if there's been any changes since then.
It was
Mr.
adjourned
Papen?
until next Thursday.
No, okay.
Is bonds going to continue 10,000 on each charge?
Yes, Your Honor.
Right. Okay, so what's your recommendation then, Ms. Six?
Then, Your Honor, my recommendation would be similar in this case. He, it appears, was arrested on the 25th, so he would be entitled to 11 days credit. So the friend of the court would be requesting just 11 immediate credit for the 11 served, as he had a balance of 26 over his head, and setting a review for February 27th at 10 a.m.
The court had noted that he had 27 days over his head. And
Oh, sorry,
the records
27
reflect-
days. That is correct, Your Honor.
All right. All right, Mr. Papen, that's what the court's going to do. The court's going to authorize a personal bond on this civil front of the court matter. So you just deal with your felony probation, but the court's going to order that you appear before Ms. Six for review on February 27th at 10 o'clock. You get out of jail in the criminal case, come on in front of the court, they can help you find a job. You got a jobs list over here. Talk with your caseworker. Update the front of the court within any address. With respect to the jail, the court's going to order to serve 27-day jail. I'm going to give credit for the 11 days you have served. And that means you got a balance of 16 days hanging over your head. So 16 days is suspended. You can avoid that. You hold the case at those 16 days in jail. You can avoid it by simply working with the front of the court. You're young, able-bodied. You need to get a job, Mr. Papen. And the front of the court has a 4-page list. Do you have any questions?
No, Your Honor.
Okay, copy of this order will be mailed to you, as well as one fax over to the jail. February 27th, 10 a.m. is your next review date, and get a personal bond in this case. So if you can post bond the criminal charges, you can get out and get back to work and come over to the front of the court and look at the job list. All right.
Yes, Your Honor.
If you don't have any other questions, you can step on, Mr. Papen. For the record, this matter is before the court for a continued pretrial conference. Are you Kaz Vincent Sr.?
Correct.
Good morning, sir. Mr. Vincent Sr. is appearing from Monroe County Jail. This matter was before the court for a pretrial conference on December 28th. Mr. Vincent, the court did not know at that time that didn't know until that day that you were incarcerated in Monroe County Jail. In any event, you were present for this pretrial conference via Zoom. Is Crystal Vincent, you also present on audio?
Yes.
All right. Good morning, Ms. Vincent. Ms. Vincent advised the court that there was nothing at issue in this divorce case, Mr. Vincent. And you received a copy of the proposed judgment of divorce. Is that correct?
I just got a copy of something today, but I don't want a divorce.
Well, if she wants a divorce, she's entitled to it, Mr. Vincent. You can live together, you can get remarried afterwards, but if she wants a divorce, the court must grant her some no-fault divorce in Michigan. The only issue is we have property needs to be divided.
No, can you ask her, do she want a divorce?
Ms. Vincent, Mr. Vincent's wanted to know, do you really, truly, sincerely want a divorce?
As of right now, I feel like it would be best. If it's meant to be, we'll come back and get married a second time.
Does that answer your question, Mr. Vincent?
Can you tell her I said, please, let's
She can hear
continue
you.
our marriage? Can we
hear
please
you.
continue our marriage? Please, 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 love. Please, babe.
I hear
Can
you,
we just-
Kaz.
Can we listen? I will do my absolute best. You hear
Do
me?
you want to talk for a few minutes?
Please.
If we could, please.
Okay, we'll put you in breakout room too. You can talk and come back. But Mr. Vincent, I need to move this matter forward. Either Mr. Vincent needs to come in and sign a dismissal today, or we need to get a judgment divorce order. So open up your envelope. There's a proposed judgment in there that Ms. Vincent has approved. Open that, review it with her. I'm going to put you in breakout room too. You can talk privately, okay? And I'll come
Yes,
back
sir.
to you.
Yes, sir.
Spence versus Ronald Spence.
For the record, this matter is before the court for a pretrial conference. Subsequent to the parties having engaged in mediation with Mr. Walker from the front of the court. This hearing is being conducted via Zoom. Present is attorney Matthew Biddle representing the plaintiff Donica Spence. Ms. Spence appears to be present. In addition, Henry Levens is present representing the defendant Ronald Spence, and Mr. Spence appears to be present with Mr. Levens. Good morning, Mr. Levens.
Morning, Your Honor.
The court has been informed the parties have reached their own agreement this morning. Is that correct, Mr. Biddle?
Yes, Your Honor. Yes, Your Honor.
Wonderful. Who would like to place that agreement on the record?
I'll do that.
Please, Mr. Riddle.
Your Honor, the parties are going to share joint legal custody of Jax and Jaylyn. The judge is going to be silent as to physical custody in as much that that issue is going to be reserved. Defendant father shall receive parenting time with the 2 minor children every other Wednesday after school until Monday at the start of school. If there is no school, then the pickup drop-off time will be 5 p.m. The parties are going to work out the other details on a case-by-case basis, and the parties are going to mediate with Josh Walker on May 13th of 2024 at 1:30 p.m. just to see if there's any other modifications that aren't going to be in the judgment that need to be addressed at that time. Holidays are going to be, unless otherwise agreed, that the parties are going to use the friend of the court holiday schedule. Summers as agreed by the parties for child support. Father is going to pay mother $403 per month for 2 children. When there's only one, that will be $235 per month. The uninsured medical percentage is going to be paid 38% by dad and 62% by mom. Those numbers are calculated based on 144 overnights for dad and mom carrying the kids on her health insurance. The effective date for that child support is February 1st of 2024. With regard to taxes for the 2023 tax year, the parties are going to file married but separate, and Ms. Spence is going to claim both children. For 2024, each party is, and beyond, each party is going to claim 1 child on their taxes. And when only 1 child remains, they're going to alternate the remaining child, with dad having the child in odd years and mom in even years. The parties are going to evenly split all school-related extracurricular activities for the children. If there is an activity that's outside of school, they will split only when the split it equally only when the activity is mutually agreed by the parties. There's going to be no spousal support whatsoever, and is forever barred under Staple v. Staple. Parties have no real property to be divided. With regard to their personal property, they're each going to keep whatever personal property that is currently in his or her possession, with the exception of the following. Mr. Spence is going to be awarded and receive his tools and the 4-wheeler that the party's son Jax normally rides. He is going to receive, Mr. Spence is going to receive the 1999 F-250 Super Duty truck, and he's going to be responsible for all costs and upkeep related to that vehicle. Ms. Spence is going to receive the 2018 Traverse. She's going to be responsible for the loan on that vehicle and all other costs and of maintenance and upkeep. They're each going to keep their own financial accounts and retirement accounts, life insurance, and the like. They're each going to keep and be responsible for their own debts and hold the other party harmless. And my client will be going back to her maiden name of cause. That's the entire agreement.
All right, Mr. Levens, did Mr. Vito accurately state your client's agreement?
Yes, he did. Just one point of clarification for the record. Plaintiff will sign off on that 1999 Ford 250 pickup truck. I believe the title is in her name.
That's correct.
Wait, the court would note that when Ms. Spence filed a divorce complaint, this court suspended the payment of the filing fee pending review at the time of entry of the judgment so that she could pursue the matter. So that needs to be addressed. There's a $255 filing fee due. I don't know who's going to play that, or the party's going to share that. You want to discuss that in the breakout room?
Yeah, I think that I know each party is going to be responsible for their own attorney's fees, but with regard to that filing fee, Henry, do your client have any objection to paying half of that?
The filing fee to file a divorce. So would you oppose paying half of the filing fee?
No.
No. We'll probably split the filing fee.
Okay, of course, the taxpayers in this court's opinion should not have to pay for the filing fee, but the court wanted to give Ms. Spence an opportunity to start the matter. Now, the clerk's office, of course, will not accept half a payment. So the judge needs to reflect who's going to pay that. And if they need till January 31st, I'll provide the time to do that. The other party can then reimburse the other party, but the clerk's office will not take partial payments. So who will pay the $255? The plaintiff?
I can pay the $255.
Okay, and can you pay that by January 31st? Ms. Spence?
But, yeah, January 31st. Yeah.
All right, so Mr. Vito, if you can put the judgment that the plaintiff shall pay $255 filing fee to Monroe County Clerk on for January 31st, 2024. And Ms. Spence, if you need additional time, you contact the court. Just don't blow it off. You blow it off, that's when bench warrants issues. We don't want to go there. So it's the last day of January. So Mr. Vito, if you can add a provision in the judgment that the plaintiff will pay $255 filing fee to Monroe County Clerk on for January 31st, and you can add a second sentence that the defendant will reimburse her 1/2 of that amount. Will that work, Mr. Liebens, Mr. Vito?
Yes.
Yes.
Okay, all right.
Matt, can I bring up something?
Please, go ahead.
Just to understand, when you said visitations, you said 2 minor children's, we agreed on Jack's.
It's only pertaining to Jack's. Thank you.
Oh, okay, thank you.
Right. All right, Mr. and Mrs. Spence, can you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
Thank you. All right, Mr. Vito, you can begin with Ms. Spence, please.
Yes, thank you, Your Honor. Ms. Spence, you recall having me file a complaint for divorce in this matter?
Yes.
Or actually, I believe you prepared the complaint. I came in later. Is that right?
Yes, correct.
All the allegations that you had in that complaint were true at the time of filing?
Yes.
And they're still true to this day?
Yes.
Those allegations in pertinent part were that you're not currently pregnant. Is that right?
No.
And so you're still not currently pregnant?
No.
Okay. Also that at the time of filing, that you were a resident of the state of Michigan for at least 180 days prior to filing?
Yes, correct.
And that you'd been a resident of the county of Monroe for at least 10 days prior to filing?
Yes.
That's still true?
Yes.
Okay. Also that there were 2 minor children born in the marriage?
Correct.
And we just put the agreement on the record related to those 2. There are no other children that were born or adopted?
No.
Okay. Another is that there's been a breakdown of the marital relationship such that the objects of matrimony have been destroyed. Is that right?
Yeah. Yes.
And there remains no reasonable likelihood that that marriage can be preserved. Is that right?
That's right.
And that's still true.
True.
Have you disclosed all your assets and liabilities to your husband?
Yes.
Okay. You've hidden nothing?
No, I have nothing hidden.
Okay. I have no further questions.
Thank you, Mr. Vito. Mr. Liebens, do you have any questions for Ms. Spence?
Yes, just briefly, Ms. Spence, you testified that you disclosed all of your assets to Mr. Spence, correct?
Correct.
And the amount in your retirement account is less than $50. Is that accurate?
Yep, correct.
That's all I have, Your Honor.
All right, questions for Mr. Spence, Mr. Liebens?
Yes, Mr. Spence, you heard the terms and conditions of the proposed consent judgment of divorce placed on the record, correct?
Yes.
And this follows a lengthy mediation today officiated by Mr. Walker.
Yes.
And you've had time to fully participate in that mediation,
Yes.
make your voice heard and your concerns known.
Yes.
And you're confident that this proposal is in the best interest of your minor children.
Yes.
It has your consent.
Yes.
You understand everything and wish the court to enter into a order that states the same.
Yes.
Are you satisfied with my services on your behalf?
Yes.
I have nothing further.
Thank you, Mr. Liebens. Mr. Vito, do you have any questions of Mr. Spence?
Yes, just briefly, Your Honor. Thank you. Mr. Spence, you heard us place that mediation date on the record. We're going to be mediating with Mr.